Hello, everyone. Thanks for coming to the session today. My name is Clark Iakavakis. I am the Scholarly Services Librarian here at Oklahoma State. And the topic of the session today is copyright in higher education. This is part of a series of events we're doing as part of the International Open Access Week. This is a week focused on providing open access to scholarship and research. And copyright is a big part of this picture because it travels with works, and we have to be very aware of the copyrights embedded within works. So the session today will focus on multiple different aspects of copyright in higher education. I'll start off with a story. When I was a kid, I used to love the movie Indiana Jones, and I would draw pictures of it. I would write stories about it, you know, him fighting the Nazis and using his whip. And at first, these stories were just copies of what I saw in the movies, just exact replicas. But over time, I started to come up with my own scenarios, my own plots, my own characters, and they sort of became mine. The funny thing is that's exactly what happened with George Lucas. The Indiana Jones films were based on adventure serials movies from the 1930s and the 1940s, and he took those as inspiration. Those, in turn, were based on comic books and radio shows of adventure stories. Those, too, came from earlier adventure novels like Treasure Island and Robinson Crusoe. And we can trace that back all the way to the medieval era with stories of knights and chivalry and dragons. And those too have a basis in myths and epics. So the point is that creativity is really enhanced when we share access to information. And I think it's important to keep that in mind whenever we talk about copyright, that we all really share this creative spirit and we draw inspiration from each other, and think about how that affects ownership of ideas and inspiration. So copyright law is a very gray area, especially in the digital world. The law is pretty outdated. It really hasn't been substantially revised since 1976. But at the same time, this gray area is really kind of built in because the issues surrounding creativity and reuse of creative work is so complex and challenging. So it's important really for us to use critical thinking whenever we're thinking about copyright issues. You don't have to be a lawyer to do a copyright analysis. But you do have to use critical thinking, and you do have to be aware of all of the laws surrounding copyright. So I am not a lawyer, and everything that I'm about to tell you is not legal advice. It's my attempt to explain my understanding of copyright law. So that's a disclaimer. The outline today, we're going to start off by talking about what copyright is. Then we're going to discuss using copyrighted works from the perspective of a user. And then finally, we're going to finish with copyright from the perspective of an author or a creator. What rights does an author have? What copyrights happen and when someone authors a work? After each section, I'll stop and allow questions. So if you do come up with some questions as I'm talking, then feel free to ask those at the end of each section. So let's get started. What is copyright? Well, copyright is one of a few types of intellectual property which can awkwardly be defined as the intangible creation of the human intellect. Other types of intellectual property include patents. So this is the exclusive right to make, to use, or to sell an invention in exchange for disclosing it to the public. There is also trade secrets. These are formulas, designs, or patterns that are not generally known or reasonably ascertainable. In other words, someone can't just figure it out. Like you can't really go home and recreate Coca-Cola, for example. They have a trade secret over that. And trademarks. This is a recognizable sign that distinguishes the products or services of a company or an organization. So I'm not going to talk about patents, trade secrets, or trademarks. This session is exclusively focused on copyright. Well, what is the purpose of copyright? It actually goes back to the US Constitution. The founding fathers deliberated this question. They were authors themselves, so they had a real reason to think about this issue. And what it says in the Constitution, I'm going to read this whole thing. It says, it gives Congress the power to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. But what does that mean, really? Let's parse it out. It starts with the purpose is to promote the progress of science and the useful arts. Science here means just any field of inquiry. It's not just the sciences. And the useful arts is sort of artisanship, manufacturing, making things. So we can see here that underlying that, the purpose is to incentivize creativity, add new information to the conversation, promote the creation of this work. It's oftentimes we think of copyright, the purpose of it to protect, to stop other people from using work. But actually the purpose of it is to promote usage. And the way that these, they were writing in the Enlightenment, early modern capitalism, the era of the printing press, was to secure to authors and inventors the exclusive right to their writings and discoveries. In other words, legal protection to determine the ways that their work is going to be used. So at that time, it's the time of the printing press, an author would make a deal with a press to publish his or her book and print it and bind it and then sell copies of it. Well, what's to stop another printing press from taking a copy of that book, typesetting it, and making copies of it and selling it? So for many of these authors, their books were their livelihood. So they said, we need a legal protection, so otherwise we're going to stop writing books, or we're not going to be able to write books or pamphlets or whatever. Discoveries is included there as well. But the authors of the Constitution also recognize that it should not be in perpetuity. So people must be allowed to use the work eventually. That goes back to my story at the beginning. Eventually, works get reused. Now, as time has gone on and as information has become more commodified or considered as a commodity, these limitations have been extended further and further. And currently, it's the life of the author plus 70 years. I'll talk about that more later. But the takeaway from this is the underlying basis is a balance to incentivize on the one hand, but to put some limitations on the other. But the underlying purpose is to promote usage, using work to create more works. But balance is critical here, and that's where we get a lot of the conflicts in intellectual property. Well, what is the copyright law in the United States, at least? Well, it's a policy decision. So the Constitution gave Congress the right, or charged Congress with writing the law with that intent in mind. So Congress has written several laws, and the laws have changed over time, usually with the invention of new technology. There's a law in 1909 that came about when the player piano was invented. So the question is, when you have a scroll of musical composition, who owns the right to that? There was a huge change in 1976. Of course, that's when we see the invention of the VCR, the cassette tape, and media began to be more accessible and copyable. And it's been changed since, and the courts have always interpreted it across time. But that's an important thing to keep in mind. But at this point, copyright is a bundle of rights. So it's not just one right, but there's several things that you can do with copyright. Make copies. This is, you can make paper copies, so photocopies, but also electronic as a copy. So if you email a document to someone, you're making an electronic copy. And technically, that's a right that is reserved to the copyright holder. Publicly distribute those copies, again, selling, renting them, leasing them. Making derivative works, so for example, turning a book into a movie or a movie into a book, translating a work, creating other new works that are based on that previous work. All of those are rights that are reserved to copyright holders. Public performance or display, so films, showing a film, playing songs, displaying graphics or sculptures, that's all considered to be display. And the copyright holder has the exclusive right to license any of these above rights to third parties. So, question, raise your hand if you own a copyright. Anyone here? Just a few people. So here's another question. Raise your hand if you've ever taken a picture, written an essay, taken a video, sent an email. So, everyone owns copyrights here. We all have more copyrights than we know what to do with. And we're going to pass those copyrights down to our heirs when we die, and they'll have exclusive rights to all of that for the next 70 years. And they'll be most likely blissfully unaware of that. But the vast majority of those will never be profitable. This is okay, but it does make for a very confusing system. So, what's protectable by copyright? I'm going to go through this. An original work of authorship. So here, when we say original, it doesn't mean that you're the first one who's ever thought of it, but it really more means it owes its origin to the author. So it's the result of an independent effort. It's not the result of copying or just stating a fact. Authorship here means any literary work, musical work, as I was saying earlier, graphic artist, sculpture, music recording, any real creative work is a work of authorship. So it's an original work of authorship with a modicum of creativity. So this can be slight, but it means that you're adding some of your own unique expression. An example of this is, we'll go in the area of patents and say a chair. A chair is in itself not protected, but if you make an elaborate chair with a design and patterns and scrolls and that sort of thing, then that has a modicum of creativity to it. So it's sort of like, how many choices does it take to create the work? Giving directions is another example. If I say, take a right on Perkins and a left on Hall of Fame, that's pretty straightforward. But if I'm adding flourish, if I'm adding description and say, you turn right at the old plant where my grandfather used to work, that was, and you're adding creativity to it, that verges closer to protection. Then it has to be fixed in a tangible medium of expression. So it can be expressed in many different ways, and it's the expression itself that's protected. If it stays up in your head, it's not copyrightable. You can't say, hey, I was going to write that book. I thought it all through. You have to actually fix it in a medium of expression. And that just means anything that can be perceived. So something saved on a hard drive, recording something on tape, sculpting something out of marble, all of that is a fixed medium of expression. And how do we get it? It just exists from the moment of creation. Beginning in 1989, you no longer had to register it. You no longer had to write the C with a circle in it, or say any magic words like, I own exclusive right to this work. You don't have to register it with the government. You don't have to even formally publish it. It just happens. That's the way that the law works. So what this means is that you have to assume that a work is copyrighted when you come across it, unless it's otherwise indicated. That's how it works in the United States. So what is not protectable? If it's functional or utilitarian, like earlier my directions example, there's only one way to say it. Facts are not copyrightable. So the fact that the Second World War lasted from 1939 to 1945, you can't copyright that. But you can copyright an analysis of its causes and its outcomes. Ideas, as I said earlier. So for example, there's loads of books about star-crossed lovers with a tragic ending, but Romeo and Juliet, so it's in the public domain now, but if someone was to write it now, they'd have copyright to that work, right? Titles and slogans, those may be trademarked. You can maybe trademark those, but there's usually not enough creativity to go into copywriting them. Data is a very interesting case to the extent that it's merely a measurement of an observable fact in the world. It's actually not copyrightable in the US. So it could be that the presentation of the data is copyrightable, depending on how much creativity went into it, like charts, graphs, or visualizations. But the question is, how many creative decisions did the artist make, or did the author make to present that? There was a case in 1991 where this company was charged, this phone company was charged with putting together a phone book. And rather than going out and collecting all of the phone numbers, they just took them from an existing phone book company and just put it into their own directory. Well, that company had put some fake entries in there, and so they caught them and they sued them, and they said, you can't take that, it's copyrighted. Well, the court actually found against them, and they said all it is descriptive names listed alphabetically. There's no creativity there. And this was really significant for copyright law because it meant that despite the effort that it took for that company to put together that directory, that wasn't the determining factor. What this is called the sweat of the brow. So that's where it stands now. It'll be interesting to see how that evolves over time. In Europe, they do actually consider how much effort it took to put the database together. So it is considered to be a property right. Methods aren't copyrightable, but they are patentable. Scientific discoveries belong to the public domain. Works created by the federal government, most of those are not copyrighted unless they involve some form of contracting out. This is not necessarily true of state and local governments, but most federal government documents go into the public domain. Work where the copyright is not claimed, so it is possible to dedicate a work to the public domain and say that anyone can use it in any way that they want to. And then finally, work that has fallen into the public domain. So I've said that many times now, public domain. What does that mean? Well, most works, as I mentioned earlier, will be protected until 70 years after the death of the author. After that, the work falls into the public domain, and anyone can do anything they want to it. So I could take Romeo and Juliet, I could print it on my computer, bind it, and sell copies of it, and no one can do anything. I can perform it, I can turn it into a movie, I can turn it into songs. It's in the public domain. That means anyone has access to use it in the way that they please. If a work was created by the employee of a corporation acting within the scope of their employment, the copyright will last either 95 years or 120 years after the creation of the work, whichever is shorter. So in 1998, works created in 1923 were about to go into the public domain. the previous law said 50 years after the death of the author. But a group of companies and others lobbied Congress to extend that term for 20 years. Does anyone know why, what those companies were fighting for? Disney. You got it. That's right. That's right. It was named after Sonny Bono because he was the congressman who endorsed the legislation, and he passed away, and so they named it after him. But Disney cartoons, the early Mickey Mouse cartoons, were about to go into the public domain, and that meant that anyone could do whatever they want to Mickey Mouse, and Disney was terrified of that. So they, among others, lobbied to extend that 20 years. That extension is up next year. That's 2019. So from what I've been following, it doesn't seem like there's much momentum pushing against that right now. So it is quite possible that we will see works created in 1923 fall into the public domain on January 1st of 2019. And that also means that every year subsequent to that, so in 2020, we'll get to see works from 1924 and so on if Congress doesn't take any kind of action. So, but public domain is why there are hundreds of adaptations and derivatives of Romeo and Juliet and Shakespeare's plays, but there's never been a movie for Catcher in the Rye, because J.D. Salinger's estate is very protective of that work, and they've never licensed it to anyone, the right to make a film out of it. Okay, let's pause for a second here. Does anyone have any questions? Okay.
You said you had patent beside methods, and I'm guessing scientific discoveries, that those are patentable but not copyrightable, is that correct?
Right. Methods are patentable. Discoveries actually belong in the public domain. The expression of the discovery, so the article, for instance, that reports on the discovery is copyrightable, but the discovery itself is a fact. It's an observation of the world, depending on, I mean, there's gray areas there, but so what I'm saying is observations of the natural world are, so the fact, genetic expression of a particular animal, right. So, yeah, I guess I should qualify the word discovery. An invention is patentable. But this raises all kinds of issues in terms of pharmaceutical drugs. Is the discovery that a particular drug cures something, is that a commodity? Is it a patent, or does it belong collectively to the public? A lot, yeah. An area for the courts to decide. Yes?
So I give a lecture, and I didn't do it out of lecture notes, just out of my head, or I'm BSing or something. Can somebody write that down and own the copyright to it?
If you give a lecture and someone...
I never put it in a tangible medium of expression. Do I have the copyright to it, or can somebody else?
You have the copyright to it. It's your expression. So if someone was to write down the words that you said, the fact that they wrote it down does not mean that they now have copyright, because you were the original author and it was your expression.
Okay.
Yeah.
They could perceive it and count it as my having, quote unquote.
Right, you are the author. Exactly. Yeah. But their summary and synthesis of it may not.
You see, what's behind my question is
Mm-hmm.
where I did my graduate work, and maybe here, I don't know, I haven't heard this for a long time. Enterprising students developed a note network. You heard of this?
The Note Network, I have heard of this.
Okay, so that they would take down notes from professors' lectures, and then they sold them off campus. They would synthesize it and sell it off campus.
Right.
You can imagine the faculty is just irate.
Right.
That there's this whole legal thing that I don't know that they ever resolved.
Yeah, it's a great question.
The enterprising students versus the professors wanting to hold on to the right of the
So the question is, if students take down notes and then share those notes and even sell those notes, is that copyright infringement? And my perspective would be yes. I can't really say definitively, but my interpretation of that would be you could at least find them infringing on copyright. But if it was their own summaries, it's possible. I'm going to talk next about fair use. So if it was their own summary and their own interpretation and synthesis, it's possible that it is legitimate. Yeah, and it sort of depends.
That might be where the students possibly had some of the copyright if they made some kind of summary at the end of the.
Right.
You've got work that's probably can be attributed to the lecture of the, to the faculty who made the script, who provided the lecture, and then in between that, interspersed with that, maybe a summary that's drawing in other insights. So I think there's still a copyright violation.
So.
It's kind of mixed. You see what I'm saying?
Yeah, I do. That's a great segue into this next portion where we're going to talk about using copyrighted works. So copyright law grants all of these exclusive rights to a copyright holder, and but we still need to be able to use copyrighted works. And there's three possibilities here that I'm going to review. Well, let's first talk about what use means. Does use mean making copies? Does use mean to distribute copies, to make derivative works? Those are all questions. And they're pressing questions in the digital age. I didn't just right-click, but that's an example of what happens when you right-click. Just because you can right-click on something, copy it, paste it, or save it, that's a type of use, and that may be protected by copyright. So the fact that it's easier in a digital age does not necessarily mean that it's legal. So that's the question we want to know. How is it possible to use copyrighted works legally? Three types that I'm going to review: permissions, statutory exemptions, and fair use. Let's start off with permissions. Sometimes permissions are granted by the copyright holders. An example of this is those long list of end user license agreements that we all just click I agree to. Terms of use are also an example of that. So in lots of legalese, the owner gives you permission to use the product in a very specific way. And by agreeing to that, you're effectively entering into a contract with that copyright holder. So if you violate the terms of that contract and use it outside of the scope of the permissions granted, then you're potentially liable for infringement. You've broken the contract. Movies often explicitly grant permission to watch the movie in private exhibition, although that may be covered in the statute, so I'll talk about that in a moment. But they state right out, you can watch this at home, because if no one could watch the movie, there'd be no point. You can watch it at home, but you can't show it in public, and you can't make copies, of course. Creative Commons, which I'm going to talk about later, is another way of copyright holders saying, I grant you permission to use this work in a specific way without asking me permission. So I'm keeping copyright, but I'm saying that you're allowed to make copies and distribute it without asking me for permission. And as long as you say you attribute it to me. If you don't attribute it to me, then you've broken the contract and you're possibly liable for damages. So, I also wanted to say about permissions that you can ask for permission to copyright holders. So if the permission hasn't been clearly given, and if you don't have statutory or fair use permissions, then you can write the owner and say, I'd like to use, for example, I'm writing a book, you have a picture in your work, I'd like to use that picture in my work. Or say Stephen King often includes a lot of lyrics in his books. If you look at the beginning of it, you'll see that he's giving credit, he's giving thanks to the, either it's the production or the music production company or the artist for giving him permission to reproduce that work and stating that they still hold the copyright to it. So if you're writing a thesis or dissertation, you may need to ask permission to include the survey instrument in your appendix. But copyright holders, as the exclusive owners, have that permission to grant you the right to reuse it. If you are going to do that, it's good to get it in writing and saying as clear as possible what the work is, what permissions are given, how long, who's giving it, and other sorts of details. Now, there's also a number of exemptions built into the copyright statute, and I'm going to go through these one by one. Many of these have to do with teaching and library related, and this is also kind of an implicit recognition that the purpose of copyright is to incentivize creativity and reuse. The first one is called the first sale doctrine, and this says that the owner of a physical copy of something can use it any way they wish and display it to people as long as it's private and not public. So the libraries use this heavily to build our collections. If we buy a book, the first sale doctrine states that we have the right to put that book on the shelf, put it in a display, loan it to someone, and do whatever we want with it. The law explicitly grants us that permission. Don't need a license. Section 108 is dedicated to rights for libraries and archives. This one's very interesting. It allows for archives to make a copy of an unpublished archival item. So say someone donates their personal papers to an archive. The law says that the library has a right to make a copy of that for preservation purposes. We can't upload it to the internet, we can't send it around, but we can store it locally for archive and preservation. If it's a published item, then we are only allowed to make a copy if we're unable to obtain an unused replacement copy at a fair price. And one of the qualifiers here is if it's in an obsolete technology. So it's sad for me to say that VHS is now an obsolete technology. So if we have tapes in the collection and we can no longer get an unused copy, say it was never converted to DVD, and our copy is deteriorating as tape tends to do, then we have a right to make a copy of that and a digital copy of that. But as with the unpublished item, we can't digitize it and put it out on the web. Section 110, this applies to performance or display in the course of teaching. So a teacher is allowed to show a film in any facility being used as a classroom as long as it is for the purposes of instruction. So when I was growing up, I grew up in Colorado, we often would have snow days and we couldn't go outside for recess, and they would play movies for us. They were infringing copyright because it can't be for entertainment purposes. You can only show films in the classroom for the purposes of education. And then finally, the TEACH Act was passed in 2002, and this was an amendment to the copyright statute. This applies specifically to distance education. There's some question there whether what's called asynchronous instruction. In other words, synchronous instruction is when everyone is in the class and listening and there and present. Asynchronous instruction is when you put some materials up on the web and people access it on their own pace at their own time, generally speaking. So there's a little bit of lack of clarity in the statute. It does say that the instructor has to be involved in teaching the course, but that doesn't mean that they have to be there at all times monitoring every second of it. But the TEACH Act has this huge list of requirements, and it really is, some would say, burdensome. So you have to ask, will the copyrighted work be performed as part of instructional activities? Is the online access restricted to students in the course? Was the work you're using marketed primarily for online instruction? In other words, there's these companies that create instructional materials for digital teaching, and if that's the case, then you may not be able to use it as under the cover of the Teach Act. Has the content been selected by the instructor? And this is the big one, really. Is the display of the work in an amount comparable to that which is displayed in an in-person class? So for example, if you're teaching an art history class and you're showing slides on your PowerPoint, that may be eligible under the Teach Act. But there's a lot of gray area there when it comes to showing a film. Typically, if it's a documentary or a non-dramatic work, it's okay. But if it is a dramatic film, like a movie production, then it's likely not going to be covered under the Teach Act. So again, there's even more here. The materials are the proper type, the amount that the law authorizes. The materials are not among those that the law excludes from coverage, and so on. So criticisms are that it's burdensome, it codifies what would already be fair use, and that it does not address the unique needs of distance education students. So I can answer more questions about that at the end. I'm going to talk a little bit more about fair use. Now, fair use exists because the limitations or the exceptions are so limited. Those ones that I just listed, that's a very restrictive context, right? That people need to use work in all sorts of different ways. And the exceptions, some countries' laws do try and list out all of the exceptions to the author's exclusive right. But you can imagine technology is always evolving and changing, and you can't really anticipate every use. Like no one before the early 2000s would have really thought about mashups as an exception, or sampling before the 1980s. So fair use is a way of permitting use in certain contexts without having to list out all of the exceptions. And fair use asks, would allowing this use go further towards promoting the goals of copyright law than disallowing the use? And remembering the goals of copyright law are to promote the progress of science and the useful arts. There are 4 factors that courts decide when they're doing a fair use analysis. We can all do a fair use analysis ourselves, but only courts can definitively decide that something is or is not fair use. We can just approximate. And it's a spectrum, it's a balance, each one of these factors. It's not yes or no. It strongly favors, somewhat favors, on both sides. So let's go through each one of these fair use factors. The first factor is the purpose of the use. If it's education, scholarship, research, reporting, these are all also First Amendment rights, right? Congress can't pass any laws abridging the freedom of speech, so that factors in here as well. If it's nonprofit use or if it's transformative, this strongly favors fair use. There's a couple of good examples of transformative. A parody, for example. If you've ever seen the movie Spaceballs that's making fun of Star Wars, or like Saturday Night Live skits, those are parodies. A parody has to use elements of the work itself in order to make fun of the work. So if you can't use the work, you can't make fun of it. So that's explicitly favoring fair use. That's the law recognizing that there is value in parody, in making fun of something, using it. Another example of transformative use is Google Images. So Google, sends its spiders all over the internet, copies everything, stores it in its massive server farms, and then they detect what images there are. So if it finds a JPEG or a GIF or a bitmap file. It detects that, and then it creates Google image search, so it finds what other words are surrounding it, so that people can type in words, and it will show you a little thumbnail of that image, so that you can then navigate to that web page that's hosting that image. So Google has made copies of other people's content, and they actually were sued. They were sued, believe it or not, by an adult magazine for making copies of their images to develop their image search capability. And the court found in favor of Google. And they said this is a transformative use. They're taking these images, they're doing something completely different with it, enhancing people's ability to discover it, and therefore it's a transformative use. So transformation looks at whether it adds something new with a different purpose or alters the first with a new expression or meaning. Weighing against fair use is if you're making money off of it, or if you're using it in a decorative way or a non-critical way. Second factor is the nature of the copyrighted work. So in this case, factual works, not works of nonfiction, are less favored than creative works. And published works are less favored than unpublished works. And the reason for that is if I haven't published something, let's say I'm writing a book, and I tell someone about it and they use portions of it, then they're depriving me of the ability to put that work out. So the nature of the copyrighted work, if it's published, it's favoring a fair use. The factor 3 is the amount and substantiality of the use. So for this one, it favors fair use if you're using a small amount, if that amount you're using is peripheral to the work, and if you're only using as much as is necessary for your purpose. Weighing against fair use is if you're using a substantial amount of the work, or if you're using what's called the heart of the work. This came from a case in 1985 when Gerald Ford was writing his memoirs. And there was a portion of his memoir that everyone was looking forward to reading and learning more about. And that is, what was he thinking when he pardoned Richard Nixon? So the publisher, Harper & Row, entered into a contract with Time magazine to give them exclusive access to report on the book, to give their book review. Well, another magazine called The Nation, they were sent an advanced copy of the book. They read it and they published a review about it. And in that review, they copied about 300 words just out of an entire 500-page book, just 300 words, but it was the exact thing that people were looking forward to reading, Ford's thought process in the pardon of Nixon. And so the courts, even though it was a tiny bit, the courts found against Nation. It also helped that the book hadn't yet been published, so it was anticipating publication. But that's where this heart of the work came from. So you can see there's so many shades of gray, and with these factors, the fact that this one weighed so heavily against fair use was enough for the courts to decide against the Nation. So the question is really, you can quote more than that amount, more than like 300 words, but if you don't need to use the heart of the work. And then finally, factor 4 is the effect of the market of the work. It's really market potential. So it favors fair use if you only make a couple of copies, or it's limited, or if the use stimulates the market for the work. So if it's something that people haven't really been aware of in several decades, and your use stimulates interest for it, then factor 4 may weigh more towards a fair use than against it. That doesn't mean it's in the clear, but it just means when the court analyzes it, they'll say, okay, this factor weighs more towards a fair use. If there was no impact on the market, or if there was no way for you to seek permission, then this weighs for a fair use. Now, it weighs against if the use directly substitutes for a sale of the work. So that's why a lot of online uploading a lot of online music is typically against fair use. If you make many copies, if you use it over and over again over a long-term period, and if you could have easily obtained a license or permission, then it weighs against fair use. Now, before doing a fair use analysis to say, okay, well, I'm going to use this work, let me see if go through these 4 factors and see if it weighs for or against my use, it's good to ask a few questions. One, is it protected by copyright in the first place? Or is it in the public domain? Or is it a federal government work? Is it made before 1923? If so, you don't have to do a fair use analysis. Second question, how do I want to use it? Exactly which of the owner's rights are implicated in my personal use of it? Are permissions already given? Again, as we talked about, sometimes they explicitly license particular permissions. 4, does a statutory exemption apply? And then, after that, ask how likely is this to constitute a fair use? The takeaway points is that fair use is necessary to achieve the constitutional goal of copyright law. I'm a strong proponent of a really robust exercise of fair use rights. But fair use analysis does require critical thinking. There's not just a one-size-fits-all, yes, no, black and white answer. You really have to think through it. But my advice is to be proactive and exercise your fair use rights. I was going to go through and talk about the case of course reserves. I think I'm going to skip that right now, and I can come back to it if there's interest. But let's ask, are there any questions or comments so far about that section? Yeah.
So when you go through the educational uses, this is obviously something that the one area where it's not as clear to me is that I pretty frequently will make, say, a book chapter available to students. It would be through D2L where they have to go, it would be password protected just for the class.
Yeah.
And I've always done, as long as it's like a chapter out of a book, a story out of a collection, or something.
Right.
Just go ahead and do it on multiple grounds. It's not affecting the commercial value of it.
Yeah.
It's protected to the class. In my view, it's advertising the work.
Right.
But is anybody worried about that?
That's a great question. The question was about course reserves. And so let me go ahead and talk about it, because it is an important issue to think through. So when a faculty member in the course of teaching wants to make particular works available to students to fulfill the educational requirements of the class. In 1976, Congress did recognize that there should be some use provisions for teachers that wanted to make copies of work for teaching. So they wrote this 1976 guidelines for classroom copying, where they said it should be about 10% of the work, no consumables. In other words, it shouldn't be worksheets or exams. And this was kind of the de facto standard for several years. Well, in 2008, Cambridge University Press, along with another publisher called Sage and Oxford University Press, sued Georgia State University over what they called pervasive, flagrant, and ongoing unauthorized distribution of copyrighted materials through Blackboard, through the library reserve system, through the departmental websites. And they went after them hard. They alleged that there were over 6,000 cases of infringement. They weren't seeking monetary damages, but they were really, one could infer or speculate, they were intending to really cause a chilling effect so that teachers were more hesitant to put materials that belong to these presses the copyright belonged to the presses available. This case went on for almost 10 years, from lower district courts to appeals courts, back down to district courts. And so I'll talk about the fair use analysis that the appeals court went through. So when they were trying to figure out, so many of the cases, it went down to about 100 from that 6,000. And of those 100, the district court found that only 5 of them were potentially infringing copyright. So it went up to the appeals court, and the appeals court said really that these 1976 copyright guidelines, you can't go by them anymore as just a blanket rule. So there's not a way to say, okay, if you use 10% of the work, you're in the clear. If you use 1 chapter, you're all right. That's not necessarily a bad thing, because it does require you to go really think through whether it's necessary to put on reserve. But what they said going through the fair use analysis is that the purpose of the use was nonprofit, educational, was not transformative, but it did favor a fair use. The amount, or the nature of the work itself, so if it's a nonfiction work, this actually went more towards the publishers, and they said, yes, even though a lot of these works are nonfiction, their evaluation, their analysis, and so that goes more towards the publishers. As I was saying, the amount, this really is difficult to determine. The publishers sort of wanted a blanket condemnation, but the court said, no, you really got to go through each work one by one and determine and go through a fair use analysis. And that's the direction that a lot of universities have gone. Some universities have passed their own internal policies that say 10 or 15%, no more. Others have a form that they require faculty to fill out to go through a fair use analysis. And then the market value, this was a big factor too, because for a lot of these works, there's an organization called the Copyright Clearance Center, and publishers contract with the Copyright Clearance Center for people to send them payments in order to use the work. And the Copyright Clearance Center was a party to the lawsuit on the side of the publishers. So the court said that when a license is available, then you should get a license. So the guidelines are a starting point, but there's no just bright line rule. If a license is not available, it does reduce the risk of infringement. If it is available, it depends on the first 3 fair use factors, really. You would have to pay the publisher. Right. Right. But we don't have to go that. There are some good practices that we can use so that we don't have to try and seek a license for everything that we want to make available, because that's exactly what critics of this judgment said, is that faculty will divide into 2 camps. One will say, I'm just going to do whatever I want. Right. And the other one said, I'm just not going to deal with it because I don't want to risk. There's not a huge risk of getting sued, and Georgia State decided to fight back against it. So that's sort of why it became such a big deal. But some good practices are, if there is a permanent URL, like if it's a journal article or an ebook that we have, just link out to it. It's not illegal to link to infringing content. And yeah. Right. 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 So technically, it's not against the law to just put a hyperlink because it's factual. Store copyrighted materials only if it's integral to the curriculum. So if it's like suggested or secondary, it may be better to not store those. Try and use a limited portion, and only the portion that's necessary for teaching purposes. The law does say you can only use legal copies, so it can't be a pirated copy. And display the copyright notice so that students, are aware. The access should be limited to students who are enrolled in the course and others who are involved. And student access should be disabled after the semester. If the material was produced primarily for digital instruction, then just be careful. And if the amount you think does balance against fair use, like there's a few chapters you want out of a book or several issues of a particular journal, then maybe consider if a license can be purchased. But putting an article up, putting a chapter up, most likely you're going to be just fine. Yeah. Yeah, sure. Any other questions? Kevin.
I had a question on course reserves or actually textbooks. Textbooks back in the day were in the print format and were sold, and they still have print books that you were able to buy for courses, and then there are e-books
Right.
available, and they're in some cases I believe they're available for me as a student through the end of the semester, maybe a few weeks after that.
Right.
It goes away.
Yeah.
A digital copy.
Mm-hmm.
Now, to me, that seems like I don't know, that indicates, well, that's just further indicative of the commoditization of the whole education process. It's more education incorporated than it was, say, back in, well, I mean, it's definitely moving in that direction.
Mhm.
Everything has a price, and then it's kind of, what's the right word? It's ephemeral.
Right. Yeah, so the comment is about electronic textbooks and how oftentimes textbook publishers will rent a copy to a student for a limited time. And typically there is a license agreement there that says the student's not going to copy it, not going to share it, not going to keep it in any way. It's only a very temporary or ephemeral usage. And some of that is due to high textbook costs. So the publishers make cheaper versions available. Tomorrow we are going to be discussing open educational resources, which is another way of addressing that issue, to make the textbook open with a Creative Commons license on it. So, yeah. Okay. So we have one last section, maybe about 15 minutes or so, and we're going to talk about author rights. So these are the rights that you have as an author. In most cases, the creator of a work is automatically the copyright holder, unless that person chooses to transfer it to another entity, like a publisher. So many times authors, when they publish their books, they transfer their copyright entirely to that publisher, and they're no longer the copyright holder to those books. Another way that authors are no longer the copyright holder is if they're employed under a work-for-hire policy. There is something in the copyright law called joint authorship, and this is when two people jointly create a work. And when this happens, it doesn't matter how often the order that they're listed in. If you didn't know, in academia, oftentimes the first author is the one that gets the most credit for a work. But in terms of copyright law, the order doesn't matter. If they're joint authors, then they share copyright. So they have equal rights under copyright. And they each have the right to exercise any of those rights. So that means they can transfer it to someone else. They can update it for their own purposes. They can translate it. They can do what they want with it. The only thing that they can't do is transfer that right to someone under what's called an exclusive license, which means that they say only this person or publisher can use it. If they're doing that, then the other author has to agree to it, because it's essentially stripping that other author of their rights. In works for hire, if you create something in the course of your employment, then the employer may be the one to hold the copyright, and that's often the case. So if you, after you graduate, you go on to work for a company or an organization, a lot of times in your contract, it'll be a work for hire, which means that anything that you create, the company automatically owns. Traditionally, there is an exception for this for faculty, where the university copyright policy will state that faculty are the owners of their work if it's a work of scholarship. Now, if it's a work in the course of their employment with the university, that may be different, but in terms of their scholarship, faculty or the university doesn't claim any ownership rights over that. The same with their teaching, but some of this is changing in a digital world where universities want to own the curriculum and the course content. Sometimes they'll keep offering that. If it's an online course, they'll offer it semester after semester. And so if they'll want to make sure that they have the right to do that. It's also changing as universities seek to commercialize and license patents. There was a change in the law in the 1990s that allowed universities to sell patents directly and profit off of those from inventions that their faculty had created. So a lot of universities created departments like explicitly dedicated to analyzing the commercial viability of faculty inventions. Okay, I've talked a few times about licensing and told you that they're basically contracts that allow other people to exercise some right that the licensor owns, and these may carry conditions and limitations. An example of that is Creative Commons. So this was developed in the early 2000s as a response to the restrictiveness of copyright, where copyright is all rights reserved, Creative Commons is some rights reserved. So the author is saying, rather than me keeping all of the rights that I have under copyright, I'm going to, by default, license some back to users. So it's more of a flexible management of the exclusive rights offered by copyright. There's a few different license variations from least restrictive to most restrictive. I'll go through each one of these here. Attribution means that others can use the work as long as they credit you. And to do that, they should be crediting your name, the title of the work, where they got it from. Non-derivative means that people can use the work, but they can't change it at all. So if you don't have a non-derivative license to the work, then people can do whatever they want to it. So if I put a photograph on the internet and I put it with a non-derivative, then people have to use it exactly as it is. If I don't have a non-derivative on there, then that means people can Photoshop it or do whatever they want with it, and it won't be a violation. Non-commercial means that people cannot make money off of it, and there's some complexity there, but that's basically what it states. And then share alike, this comes out of the open source software movement. So open source software is when people contribute code to develop like an operating system, like Linux, or a software application. So what was happening is you had all of these developers just contributing their code to create these programs and applications, and there were companies or members who took that code and created a software out of it and sold that software and even closed off that code so that other people couldn't see the code that was running behind the software. So they developed what is called the GNU public license, which says that this software or this operating system, if you do anything with it, you have to release it under the same exact terms of this license. So it's a way to continue feeding the commons, the intellectual commons, and that's basically what share-alike does. So it's like if there's a photograph that I release under a share-alike license and someone else does something with that, they also have to use the share-alike license so that our commons continues to grow. That's the idea behind it. So you can combine these in any way that you want to, and all you have to do is go onto the Creative Commons website and you can find any one of these. I think I'm going to move on. Many faculty at universities across the country, like Harvard, MIT, University of California, have unanimously voted to give the university what are called the non-exclusive rights to archive and distribute their scholarship. And this is a way for the university to build a database of the scholarship of their faculty. And typically, of course, the faculty can continue to publish in the journals of their choosing. The universities explicitly grant them that right, but the university also will retain this right so that if the faculty deposits a copy of their articles with them, that the publisher then cannot go after them. And after several years of this, they'll grant waivers if it's requested, but after several years of this, these universities have come to some understandings with the big publishers that they will archive a version of the author's article on their institutional repository. And the publishers basically accept that because they have to. What's called green open access, that's what I'm referring to, is when authors publish their work in a non-open access journal, but they retain their right to self-archive it in an open access archive. I'm gonna go. So when you're signing a transfer agreement with a publisher as an author, you can ask to retain certain rights. Copyright transfer does not have to be all or nothing, but you can say, I'm giving you, the publisher, the right to distribute this article, but I'm retaining the right to make a translation because I want to translate it into French and distribute it in France. So most publishers give authors the right to make certain versions of their articles available open access. Sometimes it's written into the contract, sometimes the authors must ask. I'm gonna move on here. So this is a look at some journal contracts. In terms of rights retention, there's a few different models. The first model is if the publisher takes all of the rights and licenses none back. So this sample here is from the Journal of the American Medical Association, and it says, I transfer, assign, or otherwise convey all copyright ownership to the AMA, and the AMA then does not license any back to the author. The second type is if the publisher takes some rights and licenses some back. So this is an example from Wiley where they say, after the publication of the final article, the author retains the right to self-archive on the contributor's personal website or in their institutional repository a version of the article. They also license back to the author the right to transmit, print, and share copies with colleagues. So even though this is the author of the work, if they're transferring copyright in its entirety to the publisher, then they're actually losing the right to share that work with other people, with their class, with their colleagues. So in this case, for Wiley, they're explicitly licensing that right back to the author. And then finally, there's when the author retains the right and only licenses some rights to the publisher. This is an example from the Journal of Librarianship and Scholarly Communication, where it says, first publication rights are granted to the journal publisher, but copyright for the work is retained by the author. There is a website that's called Sherpa Romeo, and this will allow you to check the archiving policies of certain journals. For example, this one says that the author retains the right to archive a preprint and a postprint, which is the version after peer review, but the publisher does not allow the author to archive the final version of record. And then if you have questions about journal archiving policies, you can also contact me. The takeaways when signing copyright agreements are it's negotiable. Before publishing, it's important to think about what rights do you want to keep? Do you want to keep the right to archive? Do you want to keep the right to translate and create derivative works? If so, you don't necessarily have to transfer that right to the publisher. But if the contract states that you retain that right, then you'll have it. Copyright session is today. If you have the right to self-archive, look at the contract and exercise that right. We do have an institutional repository at Oklahoma State University. It's called Share OK, and this is a place for faculty and students. This is where we have our electronic theses and dissertations to store that work. The library will check for copyright compliance. We'll archive the item. We'll add metadata to it, put a permanent URL on it, and ensure that it's crawled and discoverable by Google Scholar and library catalogs from around the world. And this is a screenshot of what Share OK looks like. Take-home points here: we all own copyright automatically until we sign it away, until we transfer it. If you are transferring your copyright, think it through. Try not to give away more than you need to, more than you want to. Think ahead to other ways that you might want to use your work. Creative Commons licenses, addenda, which are, you can add an addendum to a copyright contract, and negotiation are simple steps to retaining copyright, and these don't negate peer review in any way. Any questions? Okay.
So the ones with the university rights,
Yes.
I mean, I know that's been changing, but
Mhm.
what is, first of all, what happens with theses and dissertations? And is that included as part of,
Mhm.
part of that?
Yeah, so I actually copied the university thesis and dissertation policy here. So this is what it says in the OSU policy, that the university reserves an irrevocable, non-exclusive, free of cost, and worldwide right to reproduce the thesis or dissertation on a non-commercial basis. So what this means is irrevocable. The student can't come back later and say, I want that back. Non-exclusive means that the student can still transfer his or her copyright to another publisher. The university doesn't take exclusive rights like a publisher would, but it's a non-exclusive right. Free of cost, we're not charging for them. And worldwide, this is effective globally. Now, OSU policy does allow students to request what are called embargoes to that, so to withhold public access to the work. But this covers the university's right to actually make that scholarship available. Yes, this is very common. And the idea is that the work was developed in part with a substantial use of university resources, faculty time, university and library resources. And so the university does have some stake in distributing the knowledge and information. But if there are certain extenuating cases, then the student can embargo it. But that's less common. Any other questions? All right, well, thanks very much for joining me. Thanks. Thank you.